Am I in the right platform here? So quiet.
Morning, General. It sounds to me like the right platform.
Okay, morning. How are you?
I'm okay, thanks. How are you doing?
Fine. Are you recovering from your flu?
Yeah, well, it's not flu, but yes, I'm under treatment. I will be fine. Thanks.
So less noise then if you are still sick. Don't talk too much, eh?
You wish, General. You wish. And it's a wish I won't grant you. Thanks, General.
Okay. Thank you.
Recording in progress.
Good morning to everyone on the platform. I would like to apologize for not starting on time. The chairperson is struggling to log in. He's having network problems. As soon as he logs in, the meeting will start. Thank you.
Good morning, honorable members.
Morning,
Morning, Chair.
Morning, Chair.
Yes, I just went out to answer another call, but it was on a radio talk show. My apologies for starting some few seconds or minutes after the requested time. Let me take this opportunity to welcome all the members and also the members from the DMV department. Also welcome the support staff from our DMV. Welcome also the executive in our meeting. Also welcome the parliamentary communications and live streaming. Welcome our Deputy Minister, Honorable Richard Mukungo Sope, and welcome everyone in this meeting. I would now want to go to the second item that deals with apologies. Anything, Secretariat? Secretariat? Do we have apologies? Hello.
Chairperson,
Hello.
how are you, Chairperson?
I'm very well, and how are you, Honorable DM?
I'm okay.
Yes.
Do we have a quorum, Chair? Already?
We do.
Okay.
Yeah, we do have a quorum. Let's also welcome Honorable retired Major General Bantu Olumisa. Secretariat, there's a question, quorum, and apologies.
Chair, good morning. It's Willem van Rensburg. Chair, Amanda seems to be struggling to connect to speak. I'll just double check with her. Maybe we can just postpone the agenda item on apologies. She has a list of apologies. Secondly, in terms of quorum, there's sufficient members for the meeting to continue. There's no decisions made at this stage, so there's no need for a quorum. I will go through the list, but there's sufficient presence for the meeting to proceed, Chair. Thank you.
Thank you very much, honorable members. Let's proceed because I'm also aware we have. Let me just go through the members who are present here. It's myself. It's Honorable Kalniaus. It's Honorable Chris Hatton. It's Honorable Munyai. It's Honorable Hala. It's Honorable Pele. We have also Honorable Kubukeli. We have no, we are enough. Honorable Plakis is also here. So Honorable Non-Danger is also here. So we have over 8 members present here today. So I don't think there's a problem in relation to the quorum. We can move to adopt the agenda. Can we get a move and a seconder?
I move, Chair, for the adoption of the agenda.
Thank you very much, Honorable
Madam
Lindehouse.
Chair,
Second.
second for the adoption of the agenda, Honorable Chair.
Thank you very much, Honorable Munyai. We can then move. We have only one item today. It's a continuation, actually.
Sorry, Chair.
All right.
Sorry, Chair. Can I just, there's one apology from the Honorable Minister. She's hosting the Minister of Defense from Mozambique. Thank you, Chair.
All right. Oh, no, thank you very much. I'll now give over to the members of the executive to open up as the leaders of the delegation to the portfolio committee. Honorable Holomis and Honorable Mukungo. I'm not sure in terms of the position of the executive who would be leading the delegation. Let me hand over to yourselves to lead in this item.
Thank you, Chairperson. Babum Kungo, are you leading or am I leading or are we jointly leading? Which is which here?
Hi, jointly leading, Chair.
Go ahead.
Thank you very much, Chairperson. As all of us will be well aware about the High Court judgment against DMV, we have come before this committee so that we do a formal presentation on how this happened, update the honorable members of our parliament, and share challenges as a result of the effects that will haunt the department with regard to actual implementation of the judgment. We have our acting DG who will be leading the presentation. I'm not sure, I can't see our ambassador here, but AG DG will lead us on who is going to present and accordingly present before this portfolio committee. ADG? Oh, I can see ADG.
Thank you very much, DM. Good morning, Honorable Chair. Good morning, honorable members and honorable DMs and colleagues. Just to indicate, Chair, that as part of the intervention that is done by the Transversal Ministerial Task Team, the presentation today on the implementation of the High Court ruling on the CMVO matter will be done by Ambassador Mseleku, who is the chairperson or the convener of the Transversal Task Team. With your permission, Chair, please allow me to hand over to Ambassador Mseleku.
No problem, Acting DG. The permission is granted. Over
Thank you
to
very
you,
much.
Your Excellency.
Thank you, Honorable Chair, and good morning to honorable members and to the honorable deputy ministers and other members. Chair, as you said in your introduction, this is actually a follow-up to the outcomes of a previous meeting where the portfolio committee had requested that the department comes back to brief the portfolio committee on the implementation of the High Court ruling. I don't know if the Secretariat is able to fly to the presentation or to actually allow the sharing with some members of the DMV so that they can actually flight it, Chair. While I'm making the introduction, I want to remind the honorable members that the chair had actually outlined 3 matters that he had wanted the DMV to respond to as a matter of urgency. And first of all, it was the matter of the implementation of the High Court order with regard to the deadlines and plans around that. Then secondly, the chair had requested that the committee be appraised on the matter of the discussions between the DPSA, the Treasury and the DMV. And then finally, on the progress with regard to the matter of the appointment of a permanent DG. And this focus is on one of the elements that had been requested by the portfolio committee. So, Chair, I'm still not sure whether members can actually see the presentation. I don't see it being shared at the moment, Chair. But I can put.
You can share on your side, Ambassador. You do have sharing rights.
Okay, I will ask then ATG, can you ask somebody to share the portfolio and to share the presentation, please? Chair, while they are sharing it, let me give some background to this matter. First of all, background in relation to how the TFTT gets involved and therefore takes the lead more or less on this. The members will remember that in 2020, a presidential task team was actually established by the president to deal with the challenges faced by the DMV. faced by the DMV, and I'm still checking whether they are able to share the thing. And then, as a result of that, the presidential task team created work streams that focused on some of the critical areas that were facing the DMV as challenges. These are had to do with one, the organizational design of the department itself. It had to do with the question of reviewing the legislation, and it had to do with data verification, enhancement, and cleansing. There was a work stream on socioeconomic support, and there was a work stream on heritage and memorialization and burial, and then a work stream on pensions and benefits, other benefits, and finally a work stream on communication. Now, Chair, the committee will therefore notice that the matter of data processing, data verification, enhancement, and cleansing was part of the brief of the presidential task team. I see now they are able to, they're beginning to share. Can we go to slide number 2, please? Please go to 2. Yes, thank you very much. This is the slide I was actually talking to, just for emphasis, because the members can now see it. Organizational design, review of legislation, data verification, socioeconomic support, heritage, pension, and communication. Next slide, please. Now, in October 2025, which is last year, the Minister of Defense and Military Veterans appointed a transversal ministerial task team because the various work streams seemed to have reached some kind of stagnation and they were not moving forward. And so the minister appointed the task team to assist re-energize the various work streams, the ones that I've referred to. And I was given the responsibility to convene that task team. Now, so the task team has therefore been working with the DMV and the Deputy President's Office and other relevant departments to assist to take forward the work of the various work streams to unlock the blockages with regard to that. And it is therefore, Chair, against this background that we started working on the matter of the High Court order as soon as we became aware of it, as we have done with other similar court matters that have faced the DMV. Just by way of example, we also, when we started, we were confronted with the court order on the SAMFA conference, and we have more or less facilitated that process to a point where the conference has indeed taken place on the 20th to the 24th of May. So in a similar way, we got involved into looking at what this court order is about and how it needs to be complied with. Hence, our convening of the meeting with the CMVO to discuss this court order on the 9th of June this month. Next slide, please. Now, Chair, the court order itself was actually issued on the 11th of May 2026. And we note, of course, that the DMV was not able to oppose or decide whether to oppose or not to oppose the matter because the department maintains it was never aware of this and also said the same thing to the CMVO at the meeting. And so we agreed with the CMVO that they would actually provide us information about how the court papers were delivered by the sheriff, etc., etc. We are working on that because that would have been a matter that concerned both the CMVO and the department with regard to at least not making a clear decision as to oppose or not. Now, let me say that the meeting with the CMVO took place in a cooperative spirit. As I said, CMVO would have preferred not to go to court. That's not as they say, their modus operandi. They prefer to engage. So we were creating a platform, and further engagements will take place. So the conclusions of the meeting that I'm going to outline here are actually reached cooperatively. There may be differences of emphasis here and there, but by and large, they are actually agreed upon. So the order has three elements to it, which, if you like, can be viewed separately, individually, as we're going to deal with them individually, but they actually are interconnected in a particular way. Next slide. Now, Chair, to deal with the court order, the first one directs the respondents, and that's the minister and the DG and others, to ensure that applicants who qualify for registration under the definition of military veterans and who apply shall be registered onto the database within 90 working days of such application being received by the respondents. Now, you'll see, Chair, that we have bolded that part because it's the important element of understanding what the order is actually. So first of all, just up front, the order is not about all applications that are currently being handled by the DMV. It's not about applications that basically came before the 11th of May. It's about applications that will come from the 11th of May into a future date for inclusion in the database. So in other words, the deadline of 90 days is not about everything, every application that is on the table of the DMV. It's about those applications in terms of the court order that are received after the 11th of May. And the portfolio committee honorable members will know that inclusion in the database is what enables military veterans to apply for benefits. So that is why it becomes the platform for everything else, and therefore why this order is the first one to come up. The meeting between the CMVO and ourselves and the DMV agreed that all applications that are received or have been received after the 11th of May or from the 11th of May up to the 9th of June, which is the date of the meeting, will be attended to and finalized by September September this year. I think the date is mid-September, 15 or 17 of September, which would constitute 90 days after the 11th of May, if we use the court ways of counting days. We agreed also on the counting from the court date of the 11th of May. So in other words, to comply with the court order, the DMV has committed to finalize all applications that are received after the 11th of May up to the 9th of June by September. Any other applications received after this date will then be complied with in terms of being finalized within 90 working days from the date of receipt. So in other words, the court directs that any application that comes forthwith, which means in the future, must be finalized from the date of receipt of application within 90 days. So 90 days is not a specific date, like perhaps a date in September. It's only a specific date for those that have it's a specific date for those that have that are arriving on the 11th of May. But it's not for all applications that are coming in the future, because some will arrive after the September date, and therefore you cannot really meet that deadline when the application is after September. So I think that is a very important point that we agree on and we actually make. Secondly, next slide, please. The second order, Chair and honorable members, is specifically from the CMVO court case referring on approval for health care. And it actually says that all applications made for access to and approval for health care, as provided in terms of the Act, must be processed and approved within the timelines that are in the regulations, especially Regulation 21(1) of Military Veterans Regulations. Now, that Regulation 21(1), which refers to all benefits, says that the DMV will notify applicants of the outcome of those applications within 30 days of the receipt of such an application. That is what it actually says. So it's basically about informing the recipients, the applicants of the outcome. And then 21(4) says the DMV will give reasons for an unsuccessful application and let the applicant know of their right to appeal, and explain the procedure thereof. That's what the regulations require the DMV. If the applicant is unsuccessful, then they must be provided with reasons, they must be informed of their right to appeal and the mechanism or procedures for that appeal. And that must happen within the 30 days. And after that, once they launch the appeal, the process of launching the appeal, once they've launched it, is it's actually then taken to the appeals board. In fact, they are launching it to the appeals board via a mechanism that is explained. Now, firstly, with regard to the healthcare applications, again, the decision was that all the applications that were received after the 11th of May to the 9th of June will be processed in the same manner as I've advised before. I can safely say, Chair and honorable members, that immediately after this decision, the department went into the applications on healthcare, and already the applications received between 11 May and 9 June were about 88 of them. Those that were received within this period we're talking about for healthcare, and all of them had been processed by the 10th of June, by the next day, by the 10th of June, and therefore the outcomes would actually be communicated to the people in line with with what I've referred to in Regulation 21(1) and 4. Now, with regard to the other elements of this particular order, it says they must be referred to the appeals board within 90 working days, and this is where we had a bit of a challenge, because the referrals to the appeals board is the responsibility of the applicant. It is not an automatic process. Once there is a rejection or there is a denial of approval. The reason 21(4) is there, which says that the applicant must know their right to appeal, is so that they can exercise their right themselves and not exercise the right, and not that the department must exercise that right on behalf of the applicants by simply referring the matter within 90 days. So in other words, the referral to the appeals board should be and is in the domain of the applicant themselves, who then have to actually appeal to the board within a certain time frame, and therefore it's not a matter that the DMV is supposed to be complying with. All they can comply with is the 30 days period, and as I've said, with regard to those that are coming in the future, that is actually the commitment that they will actually be attended to in the same fashion. Now, next slide, please. The third order, Chair, it says, and I want to read it as a whole because it's an important element, this one. It says, take all steps to ensure compliance with Section 19 and 20 of the Act number 18 of 2011, to reconstitute the appeals board, to deal with all rejections and appeals against rejections of benefits of military veterans, and ensure such board is constituted and functional by not later than 90 working days. Now, with regard to this matter, by the 11th of May, the board had already been constituted, and had begun functioning by the time of the 11th of May. In fact, if I'm not mistaken, the board was actually constituted around the 1st of March, because by the 3rd of March, we were part of their orientation, the first meeting of the board to orientate them. So it had already been constituted after nominations having been sought almost a year earlier, sometime in March or April 2025. Now, Section 20.4 of the Act gives the power to determine how the board will operate to the chairperson of the board. So we are saying this in order to emphasize here that the 90 days that is referred to here, as we understand it, is about the DMV and the minister ensuring that that appeals board is constituted within the 90 days and functional within the 90 days from the 11th of May. What we are then saying is that that had already been done, and the board started to be functional even by March, and started doing its work, looking at what the backlog is, etc., etc. However, we undertook also to communicate to the board the sentiment that, as we understand it, health is such a critical issue from a life point of view. So we would communicate to the board perhaps to look at prioritizing issues of health benefits on their table and see whether they can actually be dealt with as quickly as possible. So, Chair, with regard to the three orders that are coming from the court, the CMVO and ourselves have actually agreed on these processes as indicated. I must emphasize, Chair, that on the constitution of the board, in the discussions with the CMVO and their presentation, it appeared that the main issue was whether the minister had actually consulted the organization as required by the Act. And in our understanding at the time, we actually thought that they were referring to consultation with CMVO itself. What we said was, if they think there's anything ultra vires in the process, because 21.1 on the appeals board in the Act says that the appeal board consists of at least 3 persons appointed by the minister in consultation with the association. Now, as I say, we were under the impression at the time that the association met themselves. And we then said, look, our view is that we have complied with this one, but if there is anything that suggests that this is ultra vires, please let's have that and then we'll examine it. Of course, subsequent to that, we have more or less noted that we agree on the fact that they were talking about SANVA and not CMVO. We agree with that. It was just the impression that we had at the time, but that has been corrected. However, the issue of whether there was consultation with SANVA is still a question that has to be established between the parties, because the claim is that SANVA says they were not consulted. Our side believes that there was a consultation on that matter. In fact, they were the ones that would also have been submitting some of the proposed names. Nevertheless, the board has been constituted. It has started working. In fact, when we were at the meeting with CMVO, it appeared that the board itself had already called certain people for pre-meetings, which was proof that it was already operating. Whether it had actually gone through that in a process that would allow people to prepare is another matter that perhaps we will engage with the board. But I do conclude, therefore, Chair, on this part, that out of that meeting, the processes of complying with the order are actually in place, the plans are in place, and the portfolio committee can from time to time call for updates before September or progress in this regard at any time as it deems it necessary, and the department will then oblige. Chair, the item also, or the request, was also to address other issues of problems and challenges related to this whole process. So we deal now with the whole process of database verification, cleansing, and enhancement. That process, as part of the work streams, consists of two parallel processes. One is the process which is led by General Mashwala, which is actually dealing with the verification of applicants. Now, that emanated from the fact that many people were applying and there were a number of applications, but there was no mechanism to actually verify whether these people really were military veterans, other than just looking at the documents, which may not necessarily tell you everything. So the decision of the PTT was that that process be undertaken through physical interviews in all provinces to interview applicants, and the backlog of applicants that had not been dealt with by 2020, by the time this was established, was then given to General Mashwala to actually undertake this. The second part of it has to do with cleansing of the existing database. Now, this is based on perceptions that the database is contaminated with people who should not be on the database. People who are not deserving to be there because, one, they are not, mainly they are not military veterans. But the claim is that they were put in because maybe they are associated with either officials or politicians or whatever other mechanism. So this is a hanging issue on the database. It continues to be referred to from time to time. Also, because the whole process is largely manual, and therefore it doesn't assist very quickly to be able to pick up some of these issues. It's also not linked to other related databases such as SARS, Home Affairs, etc., which would assist cross-check some of these issues. And therefore, because of the pressure and the continued criticism of the database as it exists, the department and Treasury have discussed this matter for some time, to a point where Treasury had offered to get its team on ghost workers to also come into the department and assist with this process. And that engagement is ongoing together with Treasury, also thinking maybe we should actually outsource this request for information very soon and outsource it so that an independent body does that verification cleansing of the database, which would require getting rid of people who should not be on the database in the first place, but also classifying people who are already on the database who are benefiting according to categories, because some of them actually are benefiting fraudulently in inverted commas because they are currently employed, contributing to a pension fund, for example, but are actually getting the same benefits from the DMV. So that process, together with the processes that JIPA is undertaking, also to cleanse the database for pensions applications, are underway, and we are hoping that the cleansing part of the database will begin in earnest mid-July, because we're still going to go on an RFI, etc., etc. Next slide, please. As I said, the data verification part, which is General Mashwala's brief, started in 2020, and it was halted for various reasons, but it resumed again. 7 provinces have been done up to now. In fact, they are finalizing, they're in the process of the last kind of leg in KwaZulu-Natal, in Pietermaritzburg, and they will finish that very soon. That will be the 8th province to finish. The last province will be the Western Cape. So we're envisaging that also that process would be finalized by the end of September. In other words, we have more or less also put it within the context of the 90 days, so that everything in September, at least for the things that would have actually been in by 11th of May, would be finalized by the end of September. Even though that is not necessarily what the court order was about. However, it coincides with the fact that the target was also September. So on all those that would have applied before, and all those that have applied between 11 May and the 9th of June, we hope by September they'll be finalized, except those that I'm going to talk about just now. But the process of data verification was largely focused on non-statutory military veterans. In other words, it was actually looking at APLA, MK, and Azanla, and not the other military veterans associations that were involved. Next slide. Now, Chair, we were asked also to reflect on the challenges that this process, the whole process, faces. The first and perhaps the most difficult challenge we face, which requires some imagination and a lot of consultation and doing and fro, is the status of the current definition of military veterans. The Act defines a military veteran as any South African who A, rendered military service to any of the military organizations, statutory or non-statutory, which were involved on all sides of South Africa's liberation war from 1960 to 1994. Now, in terms of that definition, we are talking here, at first value, we are talking about the SADF, the TBVC forces on the one hand, and the Azanda, MK, and APLA on the other hand. At face value, that is what it says. I skipped B because it talks about the World War issues, and that one is very straightforward. And then C says anybody who became a member of the South African National Defence Force after 1994. The qualification for being a military veteran is twofold. One, that you are no longer in continued service of any one of these that we've talked about. In other words, you are not actually in service on any military operations. Number two, that you have not been dismissed from that service in a manner that is not of good conduct. I'm not using the language that is used by the military. I'm using the broader language. But anyway, by definition, therefore, if you look at those two definitions now, what we are confronted with is anybody who actually meets those two criteria I've talked about, but who actually is defined in terms of the brackets of A and C, belongs to the military veterans. One, former soldiers of the SADF and the TPVC forces, former conscripts. So in other words, those people that were conscripted because it was compulsory for them for 2 years. I think at some point it was 9 months, then it went to 1 year, and at some point it became 2 years. Now, those conscripted people, also because they, according to this, they rendered military service in one of the military organizations. So they are military veterans. They are also short-term recruits that used to be used by the SADF for particular operations. We have been engaging with, first from the CMVO itself. They presented us with an issue of some of the people, the members who were left in the context of the then Southwest Africa, now Namibia context, when Namibia gained its independence and they had been deployed in Namibia, and they were more or less left out in the process. They presented that as one of the cases that they need to be assisted with. But we also have a group which calls itself from the Khoisan group, which were groups of trackers mainly for the SADF, who, as they claim, were not involved in the integration processes. They were not seen to be members of the SADF, but they are now, as we met them, saying that they want to be integrated because they were left out of integration then, even though they don't qualify anymore now. But they also have formed their own association and are also coming to do the applications here. So they regard themselves as having rendered military service. Now remember, the Act doesn't really define what military service is, or military training for that matter. It doesn't actually define that. It simply says if you render military service, then it's fine. So former and current reserves who are no longer in actual service, this one gives a little bit of a challenge, Chair. Just to give an example, some of the people who are in reserves, because they are not on call-up, therefore they are not rendering the military service at this stage until they are on call-up. So they become applicants for pensions, for other benefits. And let me take the pensions issue. Now you have JIPA looking at it and saying, is this person serving? No. And they meet the means test, yes. And then they are given a pension. But the pension rule says you can't actually receive a pension if you are contributing to the pension and you are in service because of the Military Act. So when they are called, the administrative thing is now that they must be dislodged from the JIPA because they are now on call-up and therefore are not fitting the definition. But again, after a year or two, they will. So it's a very big challenge to manage that. 5, those are the non-statutory forces, MK, APLA, Azanda. 6, SANDF. Any member of the SANDF who leaves the force and is no longer in service is part of this for whatever reason. And currently the MSBS, those young children who are then been trained by the military for purposes of recruiting from them. Those that are not recruited are actually part of this definition. Now, Chair, next slide. Similar claims, Chair, can be made by those that are trained as SDU. Not can be, they are being made by those that were trained as SDU or other internal training by non-statutory forces. So in other words, those that were rendering what they regard as military service, because again, there is no definition for what military service or military training is. There is a claim that they also can be defined in this way. Now, this is a very big challenge. In fact, the PTT advised General Mashwala to actually list those. In other words, do the interviews, and if they find that this person belongs to this category, they just keep the list of those and for actual future discussion and decision making. I can safely say currently, Chair, that what has emerged from the 7 provinces is that whereas there are a number of applications that General Mashwala's group was dealing with, the number of people that actually fit the strict definition of being, if in this case, because we are dealing with non-statutory forces, of being members of MK, APLA, and Azanda, is a very small group of people. The majority of them, and it's a huge majority, are those that fall into this category of SDUs, formal and non-formal SDUs. Then you also have a number of people who are actually being rejected, in other words, denied from even getting into that list of SDUs simply because they cannot meet certain criteria that the committee itself is working with. However, they are claiming that they were involved in whatever military activity on behalf of, and they were trained by. And therefore, you'll have a number of those people who are going to be coming back to say, we were wrongfully excluded from that list. It must be remembered, Chair, quickly, that benefits that we're talking about are dependent on the budget of the state. They are not contributory. So, in other words, they're not like a medical aid where members had contributed or contribute and then the state subsidizes. Or in housing where people get bonds and therefore and then they want supplementation from the state or support. This is mainly just by the state itself. So questions in this process keep on arising, and those are questions about what we call opportunity. Opportunity that one had to be able to actually develop their own capacity to look after themselves in terms of benefits, whether it's pension or it's housing or it's healthcare in terms of whatever medical aid and so on. These particular questions are constantly being raised against the officials of the DMV, leading to some pressures even on the decision making about the applications, because somehow these are gray areas that you are actually seeing here. For example, I'll give an example here. Just between October when we started to date, the DMV has received new applications, 5,181 applications which have full documents. In other words, where the documentation is supporting the application. 5,181. On top of that, just queries on military veterans, how do I do this, what. They have got 9,293 queries, either through dedicated email address, which gives the number there, or through the other means of communication such as SMS, WhatsApp, and other email addresses. Now, we are talking here about a very short period of about 6, 7, 8 months. And the people who have to deal with this just in numbers, just for the number point of view. Remember, also these are still manuals and not automated, where a person could just receive an acknowledgement by automatic and then explanations like all these most often asked questions, etc. The people that deal with all these things in number are only about 5 or 6 officials. But they are also dealing with those that came before that October period. And now the appeal board is coming in with an already big backlog to deal with. The question that it will confront is whether it is fair to prioritize applications that only came after the 11th of May, when there have been applicants that have been waiting for almost a year or a year and a half since the last appeal board to this one. And you can imagine, therefore, the numbers change. These issues will lead to also some unfairness on the part of the DMV, and then it should be criticized of being unfair but to others. Now, Chair Treasurer has already raised concern about the unpredictable numbers. I've already alluded to that, because it's very difficult for planning to say we're looking ultimately at budgeting over the medium term or the 3 or 4 medium MTFs so much. It's very difficult because the definition and the possibilities are wide. The focus on benefits also, Chair, is a very treasuring issue. Understandably so, everybody sees the DMV only in terms of the specific monetary and otherwise benefits. Understandably so. But then it's actually mainly just a benefit department. It can't really begin to focus on all these other very noble issues of ensuring that in the psyche of the South Africans at large, the honor and dignity accorded to military veterans is also understood, internalized by every member of society here, including institutions that offer services but are outside government, to actually treat military veterans that way. The focus is largely on benefits and skewing it a little bit, because then the department becomes a benefits department. The capacity, of course, is an issue, including technological capacity. I've alluded to that. There are also issues of fraud, which I've alluded to, double dipping. There's the potential for litigation in the DMV is huge. This CMVO case is just but one of the many cases that are potentially there. We are always dealing with cases of people who raise concerns. One of the ones that is still on the table is somebody who has been awarded a huge kind of award, which is unaffordable, but actually the issue is because the court actually misinterpreted the law and used a different legislation in terms of the one that affects. So we have a number of these. It will end up being an area which is very litigious, because the one group wants you to address this matter this way and the other this matter that way, and all of them have potential to actually deal with these matters in court. It's just that they may not have the money to have done so, others may have, or all of them don't have, but because they are forced by circumstances. Now, there are ongoing discussions here to try and mitigate these, but these are, as I say, very, very big challenges. Amending the regulations at the moment is the first step that we are trying to deal with, just to be able to properly manage the numbers that you've got. Because the Act says all benefits must be subjected to a means test. All benefits. And then, therefore, the regulations that have not been done before, now we are correcting that, because part of the issue from Treasury is that you didn't implement the means test, even though the legislation gave you the authority to do so. So all regulations are being amended in that regard. I must emphasize, Chair, because I know certain members of the honorable members of your honorable committee have raised this concern, but from a different perspective. They have raised it as a kind of means of exclusion of people who have sacrificed, etc., etc. This is legislated. It says you must be subject to a means test. The state cannot supplement your means if you have them. If you have the means to actually have your own pension, why would you then want the state to prioritize you as opposed to somebody who has never had the means because they were actually somewhere else? That is the principle underlying the means testing here. We've got two more regulations that we are urgently going to be dealing with in this regard. There is the issue of prioritization. Chair, when you are confronted as an official with these issues and you don't have the means, the resources to meet them all, even if legally speaking, and I want to emphasize, even if legally speaking, you have to actually do it. Your prioritization in terms of what you have in front of you becomes an instrument that you use to deal with these matters. So prioritization continues to take place even on the health matters. Let me give you a particular example, Chair. Most of the members of the CMVO, rightfully so, especially those that are coming to apply now, are members who are of an older generation. They are now faced with a whole range of challenges of health that face us who are older. Heart diseases, diabetes, and all those diseases that affect older people, hip replacement. So most of the support they require is actually the support of a higher level in terms of cost, as opposed to the kind of support that the state can afford or does afford. If you look at health education, Chair, we have a ceiling that has been put for university, we have a ceiling that is put for basic education. If you go to pensions, there's a very clear ceiling. This is how much we pay for pensions, etc. If you go to housing, there's a ceiling. It's an RDP house that is supplemented by the DMV to actually harness it a little bit. When it comes to health, at the moment we do not have that kind of ceiling that says this is the kind of ceiling for this service or that service or that service. So what we have at the moment is that people are referred to SAMS, and SAMS deals with them as patients, refers them to private hospitals, private doctors, etc. We are currently sitting with a bill from SAMS as a DMV, which is actually very high, about 250 million or something like that. And continued referral to SAMS without that kind of clear ceiling for health is actually going to be problematic in the future, because you'll have people being treated by SAMS, but SAMS cannot be paid. And therefore, the DMV is always going to be finding itself with the AG because it hasn't settled its amount. So again, when it comes to regulations, this health issue, I referred to earlier on, this health issue is a very serious challenge for us. On the other hand, you have people who went for training, came back, they never had the medical age, never had a job, and never had anything. Now, here are the two forces competing. One who was just a conscript for 2 years and they have gone to work somewhere else, and one who has never worked anywhere, and you've got these limited resources. What do you do as an official of the DMV who's supposed to be making these decisions? Is the challenge that officials face on a daily basis, and therefore it's a huge challenge that is a threat for us. And of course, the capacity of the DMV, Chair. Now, let me conclude, Chair, by saying the engagement with the CMVO and other military organizations on these matters continues. And of course, it's not the only matters that you are trying to deal with. And as the chair had suggested, that we also report on the processes with the DPSA and the treasury. Those are ongoing, and at some stage we may be able to report on that. And we are also dealing with this fundamental issue, the issue that has been raised several times, to say, isn't the solution the review of the legislation? Now, when you get to that, again you begin to have a can of worms, because then one section of the military veterans will say, actually this whole thing came from an idea of how to create equity between those that had been serving in the formal armies and those that were in the bush. It was meant to actually deal with the non-statutory forces originally. However, the legislation evolved and became for everybody. So they pressurized for this matter to go back to that original. On the other hand, if you are dealing with the issues of military veterans, you are also dealing with SANDF members who are becoming military veterans. You can't at this stage, 30 years after our democracy, continue with this definitions of military veterans in terms of statutory and non-statutory. If you want to overhaul this, you need to relook at the definition of the future in relation to this country and what it wants to do with military veterans, without neglecting the issues that are still outstanding for all the others that are actually there. So those issues are on the table, and once the executive has engaged with them and they're ready to present to Parliament, I'm sure they will do so. But that's the work that is ongoing. Thank you so much, and thank you to all the members for listening. Thank you.
Thank you very much, Your Excellency, for the presentation. I allowed you to have your time because I wanted the members to get the full details and appreciation of what we are going through. I would now request honorable members who would want to speak on the presentation and the report to raise their hands so that we allow you to ask questions. Thank you. Yes, I see Honorable House, Honorable Munyai, Honorable Kubukeli, Honorable Hatem. Today I will start with Honorable Kubukeli. Honorable Kubukeli, then followed by Honorable House and Honorable Munyai.
Thank you, Honorable Chair.
Thank you very much. You can hit the ground running, no problem. Honorable.
Thank you. Honorable Chair, all protocol observed. I think, Honorable Chair, from the presentation of the ambassador, I feel that there is some disjuncture between what the CMVO perceives to be entailed in the court order or the deadlines or whatever, but there seems to be a disjuncture. And the ambassador is saying they've sat down with CMVO and had an agreement, but he has not shared the agreement with us. I'm not sure whether it's a gentleman's agreement or what. But what I want to say here is that we have the letter that was shared with us by the minister. And there is a letter that was written by CMVO, which I shared with the members on our group, which is dated the 17th of June. And when I read both letters, because the letter of the minister is responding to yourself, Honorable Chair, and the committee, is speaking something else which the ambassador has just explained to us. And the CMVO is saying, if I can just summarize, to say the CMVO is unequivocal in saying that the court order imposes a single fixed compliance deadline, that is the 17th of September, and they calculate this using the 90 working days, and the minister instead introduces a rolling 90-day cycle, meaning the court order has no single deadline at all. So this is a direct contradiction between the statutory, the CMVO and the executive authority, So, and another one, on the May 11, 2026 application, the CMVO states that all applications submitted on or before the 11th of May must be processed by the 17th of September deadline. They further record that the DMV agreed to verify all outstanding cases using the SANDF threshold system. The minister, on the other hand, narrows this dramatically, stating that only applications received on 11th May fall within the 90-day window, and that applications received between 11 May and 9 June will be finalized by September, only as a negotiated arrangement, that is not a legal requirement. Now the question is, why is the department narrowing the scope of the court order? Thirdly, on the healthcare applications and appeals, the CMVO emphasizes that the DMV must comply with Regulation 21, which requires written notification within 30 working days, and that the DMV must stop using unlawful rejection grounds. The minister, on the other hand, is saying it does not mention the Regulation 21 at all. It does not acknowledge unlawful rejection grounds. It does not address the historical backlog dating pre-COVID. Instead, it repeats the same rolling 90-day interpretation used for the database. Then, on the fourth one, on the legality of the appeals board, this is the most serious divergence between the two interpretations. The CMVO states plainly that the appeal board is unlawful because the minister did not consult SAMVA, that is the statutory body of the military veterans, as required by Section 21(1) of the Act. They note that SAMVA itself publicly confirmed that no consultation occurred and that the minister admitted in Parliament that consultation did not occur. I'm the one who was posing that question to the minister, and I can agree with that. So the minister's report responds by asserting that the board is already constituted, already functional, and that consultation was not required with CMVO. Not mentioning that CMVO is part of SAMVA, So it's not about CMVO more than it's about SAMVA. If you are saying CMVO, you are saying SAMVA, in other words. It's just like any other member formation of SAMVA. But the minister's report does not address the central issue. Was SAMVA consulted, yes or no? The CMVO says no, SAMVA says no, the minister previously said no, yet now, it's not even going there. So, also, on transparency and public information, the CMVO notes that the DMV website still displays the 2023 appeals board. Nominations submitted in 2025 were never acknowledged. Minutes from the 9th June meeting are not finalized. The minister's report claims a common understanding was reached on 9th June, but provides no minutes, no record, and no evidence. So The question is, how can there be a common understanding when the parties disagree on every material point? Honorable Chair, we want to assist the DMV to comply. That is what we want to do as a committee. And this is not assisting us. Can they please just, be something? I am not sure, Chair, but let me conclude there, Chair. Thank you.
Thank you very much, Honorable Niels.
Thank you, Honorable Chair, and let me thank Ambassador Mseleku of the Universal Ministerial Task Team for the presentation that he gave us. Unfortunately, this presentation was only sent to us this morning, and I want to raise my serious unhappiness about this. The Ambassador and the Transversal Ministerial Task Team must take us as a portfolio committee serious. Chair, I'm glad that this meeting is a virtual meeting because it allows me to participate. I'm still undergoing medical treatment and I would not have been able to attend physically. The participation of the economic freedom fighters in this discussion is for us of crucial concern because we are deeply concerned about the chaos of the military veterans database and verification process and the consequences that it has for military veterans. Chair, let me first of all raise my concern that we must hear from Ambassador Mseleku that they say that the court order was apparently, or the document from court was apparently not received by the department. I believe that this is misleading. No court will take a decision without satisfying itself that there's been proof of service. Someone definitely received the court papers and sat on top of them. The acting Director General must take responsibility for this. Chair, then with regards to the whole issue of the engagement between the Department of Military Veterans and specifically the Transversal Ministerial Task Team and CMVO. We certainly cannot rely on some verbal story of discussions between CMVO and the department. We need to receive a written document of what agreements have been reached between CMVO and the department. And if they fail to do so, we have to ask CMVO to come and appear before this committee and explain to us what their understanding is of the court order and what they expect. Chair, I get the sense that we're getting a court order that is being reinterpreted by the Department of Military Veterans in the way that serves them and they want it. If they have problems with this court order, why don't they approach the court to appeal if they believe that there are issues of error of law? As the ambassador pointed out, the court made 3 clear orders. Register qualifying veterans on the database within 90 working days of receipt. Process healthcare applications within 90 working days. And ensure the appeals board is functional within 90 working days. Sadly, and I think disingenuously, the DMV's response reinterprets these orders. It claims the 90 days applies only from the 11th of May onwards and commits only to clearing applications up to the 9th of June by sometime towards to the end of September. Chair, the disconcerting issue is that this leaves pre-11 May applications unaddressed and creates another indefinite exit clause, because that's what it is, the creation of an indefinite exit clause. As our parliamentary researchers point out in their paper, we still do not have a clear completion date for all outstanding registrations, nor internal monitoring mechanisms for ongoing compliance after the backlog is cleared. On healthcare and appeals, the DMV is equally vague. Outstanding applications that have been pending for a long time are not properly addressed. We are told that the appeal board is said to be functional, and I put that in quotation marks. Yet we have no plan to clear the huge backlog or confirmation that it is fully capacitated. And most seriously, Chair, the Verification and Cleansing Committee, chaired by Major General retired Mushwaula, has dragged on for many years, covering only 7 provinces. And the EFF has said so before, and I want to state it today again, this is a national disgrace. Under General Mushwaula's leadership, the process has failed dismally. We repeat what we've said before. Major General retired Mushwaula has failed and must be removed forthwith. I now want to ask the following 5 questions. What is the expected completion date of all, and I underline the all, Chair, outstanding database registration applications, including, not excluding, including those received before the 11th of May 2026? How many have already exceeded 90 working days? And what internal monitoring mechanisms will the DMV establish to ensure ongoing compliance with the 90-day rule after the current backlog is cleared? My second question, does the DMV maintain that the court's 90-day timeline was intended to create a rolling process, which I believe is disingenuous from them, without a firm deadline to clear the entire historic backlog? Or is this, as is my interpretation of what they shared with us today, just another self-serving exit clause? My third question, what is the current number of outstanding healthcare applications? Especially, how many have exceeded the 90 working day period? What is the average processing time? And what are the projected financial implications for full implementation of Order 2? Fourthly, is the appeals board fully capacitated? We're told that it is. I doubt it. Or are there continuing to be key vacancies? What additional resources does it require? And what is the detailed plan with monthly targets to clear the existing backlog of appeals? And my final question, given the significant delays in appointing a permanent director general, despite previous PCDMV recommendations, will the minister provide full details on reasons for missed deadlines, signatories to extension decisions, and immediate steps to finalize this appointment? It's not directly related to this presentation, but it is critical because the DG will be the implementing officer. And I repeat again the question, will General Mushwaula be removed immediately from the verification committee? Chair, this committee must now act decisively. We must call for General Mushwaula to come and appear before us again with a proper compliance plan and tell us why he should not be removed, because we believe he should. With also monthly progress report with consequences for missed targets, and a dedicated oversight task team of this committee must be appointed. Veterans who fought for our freedom deserve better than this revisionist, reinterpretation, and delay presentation that we've received today. I conclude, Chair. This presentation today is not taking us out of the woods. It is going to lead to more problems. It is a reinterpretation of the law which is not clear whether CMVO and the department are in agreement, and we've got no hard evidence to the effect that they are. And I agree with the issues that have been raised by my colleague that we need to have a proper interpretation of what has been agreed, and that the contradictions as they have been presented to us today are too glaring to simply allow them to pass. If we accept this presentation, we are not going to meet the various provisions that have been set out in the court order. And I warn you, Chair, mark my words, we will end up in contravention of the ruling of the court. That is where this presentation is going to take us. Thank you.
Thank you very much, Honorable Niels. Honorable Atte.
Good morning, Chair. Thank you. And thank you also for the presentation. Chair, why are we having this meeting here today? And this is about a court order. And that court order was brought by the Council of Military Veterans Organization, which represents about 32 different veterans organizations. And they didn't approach the High Court simply to ensure that the department processes future applications and applications from the 11th of May within the prescribed timelines. They certainly did not. The department should have been doing that all along, all the years. But if that can be achieved and that is a necessary outcome of the judgments, then it should be welcome. But that was not the reason for the litigation. The case was brought to the High Court because for many years, the department's failures left thousands of military veterans unable to access the benefits to which they may have qualified. The court intervened to remedy those failures and to compel the department to comply with its legal obligations. That's the reason. So, Chair, with that, having said that, the ministers, perhaps I should call it what it is, evasive compliance raises more questions than answers. And the TMTT presentation now confirms that the department interprets the court order as applying primarily to applications received after the 11th of May 2026, rather than to the historical backlog that actually gave rise to the legislation and to the court order. That is the elephant in the room. Absolute silence about the plight of the thousands of veterans whose case was taken to the High Court by the CMVO. And a very unfortunate interpretation of the court order. So, Chair, this committee, our committee, portfolio committee, must now determine whether that interpretation is consistent with both the letter and the spirit of the court order, and whether there is a credible plan to address the historical backlog. And Chair, you know that members of this committee has been inundated with calls, emails, WhatsApps from visits from military veterans who are simply being ignored by the Department of Military Veterans. The emails do not get answered, the phone calls do not get answered, and we all know the situation, the failure of the Department of Military Veterans. So now we also have to assess whether what has been put on the table by the Minister and also now confirmed by TMTT is actually credible to address the historical backlog, what we are actually addressing here today. And whether this approach, adopted by as a convenient approach, adopted by the Minister and the Department, doesn't risk further litigation, and supported by the continued non-compliance in addressing the historical backlog that exists. So the compliance with the court order that we must overlook and have oversight on requires evidence, not a specific interpretation or assurances. Assurances we have files and files of over the years. We need full compliance. We need timelines. There's a target set. It's 90 days. And we do not need compliance with the department's interpretation of and the minister's interpretation of the court order, but we need compliance with the court order and the court's interpretation as of it. So, Chair, and I want to put this now straight. Does the department accept or reject the court order that qualifying applications, including those submitted before the 11th of May 2026, must be finalized within the court's framework? If not, please then provide the legal advice that supports this interpretation. Secondly, Chair, and if we're confronted with a 90 days timeline, we need to know the facts. How many data-based registration applications, healthcare applications, appeals, and other applications remains outstanding? And how many of those have already exceeded the statutory 90 working day period? Then we know that the department is cash-strapped, Chairperson, and this is a massive workload on the department. We know that the department owes money for many years. For instance, the $250 million that's owed to South African Military Health Services, that's not being addressed. We've got also, I think, around about 25 million owed to CETA. One of the reasons that we do not get the department fully supported by CETA on the IT side. Now, what additional personnel, what additional funding, what are being sourced to achieve these targets that they have? What are the milestones? We hear that we will be getting reports, but it should be, the report should be given to this committee against certain preset milestones, which is absent. So, Chairperson, I think the minister's response letter to this committee actually raises many more questions than it actually attempts to answer the questions. So I will conclude with that, Chair, limiting the questions as we have a very well-established history. If we ask more questions, they simply do not get responded to, and then they fall off the table and not being responded to in the 7-day period. I conclude to that. Thank you, Chair.
Thank you very much, Honorable Ateng. Honorable Mutambi.
You forgot me, Chairperson. I was supposed to speak after Honorable Nihas. I don't know whether it's by...
Okay, I'll come back to you. We can proceed with Honorable Mutambi.
Thank you, Chair, for the opportunities, and greetings to the DMs and the DG colleagues. I think the issue that one wants to emphasize, whatever we do, we must never to be seen to be in contempt of court, because there's a court order that has to be implemented. And any negotiation that happened with the applicants on this matter should have happened prior to the court judgment, because now you cannot do a post-settlement after the court has pronounced, because you had two options. If there are things, as the ambassador is saying, that are not clear, then you could have approached the court and asked for a clarification or a variation order to that effect. But now that there's a court order that has to be implemented, it has to be implemented. At the same time, the issue that comes around is that why did the court had to decide for the department to implement the act that has to be implemented, because this act was promulgated, as Honorable Hatting was said, and if there were issues that were not right, it is the responsibility of the department to bring the matter to Parliament so that the act must be amended. But as it is now, the act has to be implemented as it is. So the issues that I'm trying to raise here, we must guard against being found in contempt with the court. Let's implement the court order. Where there are things that are not clear, the court must be approached for clarification, or you have got a responsibility to also then ask for a variation order. And then the other issue that I want to emphasize, I think it's also linked to this issue of the accountability mechanism. No reasonable court will take a decision without checking whether there's been a service, proof of service. So I think we're not being told the truth yet, based on the sense that somebody did receive those court papers. Maybe either because it affects his or her responsibility, they just decided to sit on top of those papers and then denying the department the right to also file a opposing papers to that effect. Now we are here, and then I should think both the DMs must be able to come back to you to check. There must be a full report, because there is proof of service, and indeed those papers, through the state attorneys, they were served to the department. There's no such thing that the court will take a decision without also verifying whether there was proof of service. The other issue that I wanted also to raise, as the last thing that I want to also ask, this consultation that you are telling us here with the CMVOO, is it completed in all matters that affect this military veterans? And then did you agree in everything, just for the sake of interest on our part? These are the matters that we want clarity. And thanks once more for the opportunity, Chair. Thank you.
Thank you very much, Honorable Mutambi. Honorable Munyai.
Thank you, Honorable Chair, for the opportunity.
Cool.
Firstly, Chair, we welcome the presentation by His Excellency the Ambassador. And first and foremost, we'll appeal on the unity of all veterans, such that they should work together, be united, such that their service can be provided without any contestation. With respect to the presentation, maybe one point one want to raise is to welcome the establishment of the Transversal Ministerial Task Team, which was appointed recently in 2025, and the clarity that it infused capacity to address all the stagnant work stream and demonstrate a proactive approach in addressing the issues at hand. And the issues that has been identified or presented, the issues of the lack of sufficient capacity, that include technological capacity to handle the workload effectively. Maybe they must address how they're going to deal with that issues as a TMTT. Honorable Chair, we must also welcome that this the TMT would have consulted or held cooperative meeting with the CMVO. I think the question has been raised earlier as to whether it is CMVO and other military veterans or the only one that was taking us to court, because it is important that at the end of the day there have to be mutual cooperation, reaching mutual conclusion on the issues of the implementation. Chair, we also, with regard to the database verification, we have noted a parallel process for verifying the applicants. That has been led by, we should welcome it, that has been led by General Mashwala, which is underway, except we are happy that they've completed all the 7 provinces, except the KZN and the Western Cape, where they are currently now. However, Chair, there's ongoing issues that seeks to be addressed. The systematic issue or the challenges of double dipping and fraudulent benefits, which are ongoing concern. How are they going to deal with these issues without systems, On the question, Chairperson, what is the funding plan to cover these benefits, given the Treasury already raised concern on the fiscals, in the context that there's a new 10,000 veteran that has applied? The key issue is that Treasury have an obligation to address the needs of the military veterans. On the issues of the data, why are we processing the new application before we cleanse the database that they've admitted that it's contaminated? On the issues of the equity, how do you ensure that fair treatment across all groups, all veterans, not just those that have the money to fund, to get the best legal mind, who have the big pockets, though including those, those that doesn't have the money? How are they going to have a fair treatment? Because treatment should not only be for those that have big pockets, like the one that would have taken the department to court. On the issues of capacity, does the department have the systems and the budget to meet this deadline commitment, especially as per the court ruling? Because once the court has made a ruling, is the authority in the country which will require us to implement. Are they devising or developing some alternative mechanism that will implore to guarantee a success of the system to meet the court deadline of the 90 days? On the issues of the legal, it seems the issues of the court, I must say, it's well coordinated and well funded process. What the department is going to do to prevent more and future coordinated court cases that may arise. And the issues of the staff, you have raised it. I'm just worried with this, if you don't have the staff and the system and the budget, how are you going to meet this deadline? Because the ruling of the court directs you that you need to implement the court decision. And I think I'm not going to go to issues that has been raised, that really it's true that the court will not come to a determination if it's not satisfied that the issues of the service, as outlined earlier, would have been covered. And I think should it be found that there's an official who sat on top of this case and did not release the court document, there have to be consequence management. And we must receive the update in the next meeting about what exactly happened. Because if the court did not receive, the court would have made sure that all the process has been followed. If somebody would have sat on the documents, there have to be consequence management and accountability in that regard. That's all from me, Chairperson. Thank you very much.
Thank you very much, Honorable Nyai. Honorable Twele.
Thank you, Chair. Thank you, colleagues. Mine is not too long, but my colleagues already covered me a lot. But the issue is about DMV. There is a lot of files of veterans who have verified and have file numbers lying down there by DMV. Why they didn't include those file numbers to make work easier? I also concerned about General Moshwale when he's doing verification. As the late TT have formed a PTT who will work who supposed to do verification when there is a need of verification. General Moshwale is supposed to accompany it with those members who were nominated while TT alive, so that would be easy for them or for him to do verification. I also concerned about those very veterans who are old enough and long time apply for pension, even now are not getting that pension. Thank you.
Thank you very much, Honorable Twele. Honorable Nontenja.
Thank you, Chairperson, and good morning to everyone. Mine is on, I would like to know, Chair, what internal monitoring mechanism have been established to ensure the continued compliance with the 90-day working requirements after the current backlog has been addressed? Secondly, on Court Order number 1, the engagement between the CMVO and the DMV does not seem to provide clarity on when applications to the database that were received before the 11th of May will be finalized, and what is the expected date for completion of outstanding applications currently in the possession of the DMV. What's the current number that's outstanding of the registration applications, and how many of these have been pending for longer than 90 working days? On order number 2, what will happen to healthcare applications that are currently being considered or have been outstanding for a long time in terms of the projected processing time? And what is the average processing time for healthcare requests? Chair, I just hope that we are going, I've got a lot of questions, but asking questions that we don't get answers is also demoralizing. I just hope that we are going to be answered on these ones, because the matter is really serious. And I would rather pause there and wait for the second round if there's any. Thank you.
Thank you, Honorable Nontenja. Honorable Hala. Honorable Hala.
Good morning, Honorable Chair, Honorable members, Honorable DMs, colleagues from DMV. Chair, if you can check your watch, we've got almost close to 20 questions now that have been asked. And I would propose that let's allow DMV to respond now. Because if I add my question, I'll be repeating what was said by the other honorable members. Let's give them a chance to respond. Otherwise, we'll end up not getting what we wanted to get from them. Thank you, Chair.
Thank you very much, Honorable Hala. Honorable Plakis.
Thank you, Chair. Good morning, Deputy Ministers, members of the committee. Chair, as much as we've asked questions, I think this is the first time that we get this presentation on this matter. And what we are getting here is a presentation from DMV and the task team on what is going to be the approach to this judgment and court order. I think what all of us in this meeting, or what all is agreeing on, is that there's a court order and nobody is contesting the court order. There's no appeal, there's no clarification on judgment, there's nothing from any side. So we actually, all of us are agreeing on the court order and the implementation thereof. So, Chair, I don't know why we are having such a long meeting. What I would have wanted us to have now is to say, what is the project plan and timelines, time frames, and when can we get it, Chair? Because why? We agree that this judgment and this order must be implemented. Now, the most important part should be, how are we get to implement it? We've got emails this morning from the Secretary General of CMVO, and now we've got the presentation also this morning only. And in the presentation and both meetings, in both sets of documentation, they say they have met, but they haven't agreed in totality. So why don't we give them time to go and agree with timelines, time frames, and come back to us with that, Chair? That is my proposal, Chair, to the meeting. Because asking questions is not going to assist us. We've been asking most of these questions for almost 2 years. I thank you, Chair.
Thank you very much, Honorable Plakis. I thought I must bring it to the attention of DMV. When we concluded our meeting that gave birth to the meeting of today, we agreed that we get a process plan that will tell us this is the breakdown of what we will do to comply with the court order. That's what we, by and large, expect today, so that we deal with the compliance of the court order. We have no leg to stand on. This act has been in existence for 15 years. We, on the 10th of July this year, would be 2 years in office as this portfolio committee. In our first meeting with DMV, these are issues that we raised and agreed that something will have to be done, and it has not been done. The TMT is not even aware. I don't think they were fully briefed by the department in their work. Not only CMVO with 32 veterans organizations are having a problem. Even ourselves as the portfolio committee, we have a problem. I would ask the secretariat to forward to the TMT our communication with the department in trying to resolve this matter before even the court came in. Many of the things which the court raises are the things which we have raised as the portfolio committee against the department, and were not taken serious, or we were not, or we were taken light based on the concerns we raised with the TMV. Now, it's very clear from the interpretation that the TMT gave today, we're malice as the department and this portfolio committee. So what we are trying to say in that response, it's a contempt of court order. The court is clear on its 3 orders, and what we need to do is to develop a process plan of how we respond to the 3 orders. All other things we talk about, those are just an academic exercise. And I think I would allow the department led by the deputy ministers to clarify us what is the process plan and the way forward related to the implementation of the court order, because the department as it stands now, it has been outmaneuvered by events in terms of the rules of the High Court of the Republic of South Africa. The rule says if you are not happy with the outcome of a court order, you have 14 days to apply for re-evaluation. You have 14 days to notice the High Court for any appeal. And that was not done. So what is being said in this meeting today by the department, it's an academic exercise because you are outside the rules of the High Court. The judgment was on the 11th of May. You count 14 days from the 11th of May to have made an application of re-evaluation or application to appeal. And that was not done. So it's misleading to the portfolio committee for the department to give us the report you have given us outside the High Court rules of the Republic of South Africa. And that's why I would agree that we get a proper legal advice in terms of complying and ensuring that we implement this High Court order. But I don't want to speak on behalf of the department, but try to make the department and sensitize you that you are outmaneuvered by events in terms of High Court rules of the Republic. And what you are saying to us is the portfolio committee today, it's misleading. And any misleading from the side of Committee of Parliament in terms of our rules, it's a matter of ethics. And I would not want us to take this matter to the ethics committee. I would want us to resolve it and ensure that we comply with the court order. Honorable Mukungu would recall, even in 2024, October, we agreed that the department must embark on a roadshow to go to each province, deal with cases of veterans, interview them individually, gets to know who's who, from which unit, who was the commander or the commissar. We made that particular appeal to the department in October 2024. We are now in 2026. But I would not want to dwell much on matters. Allow either Honorable Mukungo or Honorable Officer to come in so that we know what course of action to take now going forward, because it's clear that if we are not careful, we will be outside the court order in terms of compliance, because we have been outmaneuvered by any alternative of the High Court rules, and it's not going to be easy. We are going to appear as delinquents, especially in terms of respect for the rule of law. Over to you, members of the executive.
Thank you, Chairperson. Honorable Chair, Honorable Deputy Minister, Olomisa, honorable members of the committee, acting DG, Chairperson of Ministerial Tax Team, Minister of Staff, we will thank this opportunity to be given to appear into this committee. Today, Chair, we have done this presentation from the department, but however, we presented matters related to the court order of the CMVO, including how the department has planned to comply with this. It does appear, Chair, I will agree with everybody, that we were made aware of the process leading to the order very late. I myself got the information from you, Chair, during the parliamentary session. You are the one who informed me about the judgment, and I was not aware at the time. But I must say that the presentation led by the ADG and presented by the Transversal Ministerial Task Team has therefore, in our view, succinctly explained three orders contained in judgment, which are mainly about the nature of the order, its implementation and time frame, the responsibility of the said respondents, the establishment of the appeals board, which had already been constituted before this court order, as mentioned by the presentation. All these orders, Chair, touch on the work that is supposed to be done by the DMV in responding to challenges facing the military veterans. Comrade Chair, but while I'm continuing, we must profusely apologize for the late submission of the
Honorable
presentation to
DM,
the... Yes?
Honorable DM, I wanted that we respect the parliamentary rules.
Sure.
Honorable, not Comrade Chair. Thank
Yeah, in our executive chairperson, with regard to this matter, we felt that there are consequences that could be negative in this process. We have agreed that we will have to sought legal advice on this matter, Chair, and come back to this committee to account.
Thank you very much, Honorable DM. Anything from the DMV or TMT?
No, thank you very much, Chairperson, for the questions and the comments. Chairperson, perhaps with respect, we can actually apologize for the distribution of the presentation. We all became aware of the possibility of this meeting on Monday, and yesterday was a holiday, so that's why there has been that situation. It's a question of the timing of the meeting that we all became aware, because the meeting was convened and we received the DMV received and the minister received the invitations on Monday, and yesterday was a holiday and other things happened. So on that one, we apologize. We apologize for that. Secondly, indeed, Chair, we are prepared as soon as we finalize the minutes with CMVO of the meeting, which may be within this week. We can then send the record of the meeting itself, because it was actually being recorded verbatim. We got that verbatim recording from the CMVO themselves, because they were using their machine to do the recording. We will send the minutes of the meeting, as well as the verbatim recording of the meeting itself, to the committee, for the committee to make its own mind as to whether we have misrepresented the outcome of the meeting. Our belief is indeed we have actually presented what was the outcome of the meeting. Thirdly, Chair, I think indeed we maybe we all need to get that legal advice on the issue of compliance with regard to the court case, because we need to make a distinction between what the committee indeed rightfully so has been raising for years, which relates to the completion of the applications of the database, which of course we can actually then be asked to prepare a presentation on the plans to deal with that backlog and with time frames, etc., etc. That is a fair understanding, which we together with the department can begin to try and meet or give some of the issues that may arise as a result. What we have in front of us, and with respect, we would actually still say, is the plan to deal with the court order as it stands. And we have an understanding of what the court order says, which we actually tested with the applicants as to whether they understand it in the same way as we do. And indeed, they had their legal minds there, who actually said, indeed, we agree with you, as will be seen in the recording that we are talking about, from their own legal minds. So we would not have acted outside their own interpretation if they didn't agree with us. We would have then said, okay, if that is the case, it's either we come to a common interpretation, or as you say, Chair, and as all other members say, we approach the court for a proper interpretation. or get the lawyers to meet on this part. But we, Chair, just to underline this, that this is not to obfuscate or to mislead the Parliament. It is to respond to what we were asked by the meeting to address, which is address how we are complying with the court order. We may not agree with what it says, and maybe that's an interpretation of the law, but from this particular presentation, it's a separate question in our view, Chair, which we can do to come and present on all the other matters which are not being addressed by this court order, or may be implied, but that's not the specifics of this court order. All matters that have to do with applications, including how the backlog is going to be dealt with, whether in health or in education or in database, etc., etc. We would be prepared to come back to the committee at a time that it would want to actually present that plan, which is we are directed to do now by members. But it is not in relation to the current court order, and we are sure that we would not be delinquents with regard to the court order as it stands, unless, of course, there is a legal interpretation that is different. So we will go back and present a legal interpretation. We'll request one, but we would also suggest, Chair, that if there is any other legal interpretation that may differ with the one we have, we can be afforded that, so that we all work from the same script. That's what we were trying to do with the CMVO. We wanted to work from the same script so that they do not go back to court and say we have not complied with their, because it's their court order, as it were. It applies to everybody, but it's their court order. And we believe that we have done that successfully, and their own lawyers agreed to us. There are matters that we then discussed in the meeting, which are raised in their correspondence here about the order itself, but they're not about the actual implementation of the order. They were about how to deal with the backlog, what possibilities. And indeed, we did raise the discussions with them around whether we should, in the first place, have actually got everybody automatically who is on the CPR, who have the first numbers and so on. Why we shouldn't actually be just getting all those in the database and only asked them to update their information. We indicated to them that that discussion is actually taking place internally because we want to see whether there are any loopholes around it. But if it is something that can be done, then we would actually say, let us do exactly that, and then they would provide us with whatever information they have on people with first numbers and everything else to update the issue. But that was a discussion that was being undertaken to say, how can we further deal with this matter, having complied with what the court order says now, but we want to deal with the matter in broader terms, and therefore, what are their suggestions? And we engaged on those suggestions. We haven't presented them here because they were not meant directly to deal with the issue of how we both interpret the court order. But we agree that there was a discussion in relation to that. Chair, the other matters that, so in other words, in conclusion, Chair, on that one, we can commit, and the Chair can say how quick that will happen, to come back now and deal with a plan or plans for dealing with the database itself, with timelines or possibilities or capacity issues, all those. But the urgent issue now was to say, are we going to comply with this court order? So we have to say, let's see if we need to comply with this court order within 90 days. And our agreement is, yes, we can, given the fact that the court order is actually futuristic and not necessarily going backwards. When it comes to backwards, for example, it would be illogical for the court to say we must finalize a matter within working days, 90 working days of such applications being received. when those applications were received almost a year ago in some cases, the court would not have said that. It is saying whatever within 90 days, working days, and it's explicit of such applications being received by the respondents. So, Chair, we will come back with legal advice as well. We are requested. But finally, Chair, on the matter of the appeals board and this legality, as we said, we were not denouncing that CMVO was actually saying what it said. We said to the CMVO, if we have proof that this matter was done illegally, we will correct it. That's where we are on the matter. And we are still investigating the issue of the consultation with SANVA. If indeed we find that there was a problem with that, we'll find a way to actually regularize it. If we need to re-advertise and do the process again, we'll advise the minister accordingly. All we said to SANVA was we didn't deny that it may not necessarily be so. We only said that we assumed that they were talking about themselves, but we also said if they have any reason which can assist us to understand, because we don't understand its illegality at this point, then they will present that. And therefore, I must assure the honorable members that this issue, that this is not a denial or a difference between us. No, it is merely a process to say if we can actually get a final position that indeed it was illegal because SANVA was not consulted, we will then look at the mechanisms to reckon that we don't want to act ultra vires, Chair. So I think those cover everything that has been raised, including the questions that were raised by the honourable members, which were specific about when this thing is going to happen, what are the plans. We are saying there's a separate exercise, Chair. We can come back and present those. This one is responding to the court order as it stands at the moment. And we hear that honourable members are challenging the interpretation. We'll go back and provide the legal advice on the actual interpretation of the court order. And we're not doing it in order to duck out, in order to whatever, but we wanted to be sure that we are consistent with what the order says. And the other, without denying that there are backlogs and therefore we need a plan, which the portfolio committee has been asking for quite a while. But what is in front of us is a specific court order that says do 1, 2, 3, and that's exactly what we are trying to do. We're not trying to obfuscate anything. Thank you, Chair, for the opportunity.
Thank you very much, Your Excellency, Ambassador Mseleko. I think we have to agree that as the portfolio committee, we leave it to the executive and yourselves to ensure that you comply with the spirit and the letter of the court order. I will officially write to the executive to notify them that we met. According to the report you gave to us, is that you are in charge of the process and you will ensure that you comply with the court order within 90 days, as requested by the order of the court. As the first one. Secondly, is that you further consult on the legal advice on how best we can ensure that we comply with this particular court order so that we are not found to be in contempt of the court. But in my case, in case of honorable members, because we have taken an oath of office to comply with the Constitution, we would be constitutional delinquent if we are not to respect the rule of law, in particular the court order. So from our side, as a separate arm of the state, which is the legislature, we implore on you as the executive to ensure that you comply with the order of the arm of state of the judiciary, which is mandated to administer law and justice in the country, and we expect you to to follow that spirit as raised by honorable members. We have to agree, as per the proposal from members, including concluded by yourself, Ambassador, that we get a full plan that will assist us to deal with all matters related to the implementation and application of the Act, related to database, education, health benefits of members, including their beneficiaries, because some of them, we talk 15 years of the Act, but some of them, like the 1976 detachment, is now 50 years of the delay and the waiting for these benefits and the conclusion of the database verifications, especially from non-statutory forces, because they are the ones which are mainly affected by the delay of the DMV department. So I would request that we ensure that that plan is presented. So I don't want to put a date on you, but we'll also write to you that we expect this plan to be forwarded to the portfolio committee within 14 days from today, so that we are clear about the plan and we are clear that the plan will be communicated with all deserving military veterans so that they know what to expect and when to expect. We made this request to the DMV in October of 2024, where we said to them, develop a proper roadshow, go to each province, get to know what are the challenges and the problems of military veterans. That was not done until today, and that's the problem that we have as the portfolio committee, that sometimes we agree with you as the department and you don't honor our agreements from our meetings, and that create this particular hostility that you see happening today, that we are not even confident that the department would comply with the court order, because we have had many court orders related to benefits and other things of the military veterans, and CMVO, which represent 32 military veterans association, took us to court, and it means that's one of the biggest stakeholders that were intransigent and in conflict with it. And I don't speak about other military veterans organizations which are there. So it creates that particular point of doubt from the side of the portfolio committee. I'm sure even from the beneficiary community of military veterans that will comply with this order, but we have all the trust in you as the executive that will ensure that we do it and bring the plan within 14 days. And I think that would be our way forward. Let me, before I conclude, allow the executive to make an input. Honorable DM Mukungo, Honorable DM Retired General Bantu Olumisa, over to you. Honorable Deputy Minister.
I just want to check, Chair. You were asking for Deputy Minister Bandolomi, sir.
Yes, I was asking for any one of the two of you to help us to ensure that the executive must comply as an arm of the state with the order of the other arm of the state, which is the judiciary, in terms of the way. I wanted the way forward from your side as the executive.
Sure, Chair. As I indicated earlier on that we deliberated on this matter, and we have decided that we will seek legal advice. Then we are going to take it from there. Noting all of those that you indicated earlier on, in that we did not appeal and days are gone. All of those, that's what we want to go through with the lawyers, and depending on their advice, then we will come back to you, Chair.
Well, thank you very much, Honorable TM. Just from our side as the portfolio committee, we take it that you'll get the legal advice, but we would request that you comply with our agreement today that we get a plan of how we deal with the implementation of the Act, including ensuring that we finalize the verification of the database and all those aspects. Then would request from your side, Honorable DM, that we, besides the plan, we get a process plan in terms of how we ensure compliance with the court order, because what I hear today, it's more of matters of law and points of argument, which we're supposed either to deal with it on the revaluation order or on the appeal, which we could not do. So what is left for us now is comply with the court order, and that's what we are requesting as the portfolio committee, so that tomorrow we are not seen to be in contempt of the court order, or either having failed ourselves as the portfolio committee to have played our oversight on the executive on something that is a public knowledge now. So that's what we are basically going to request from your side. But we hope that all of us going forward will assist each other to ensure that deserving military veterans get their benefits, including their beneficiaries, and we ensure that at least there's a win-win situation. Because the problem, if you don't deal with the matters of your military veterans are people who are trained with skills, and some of those skills are very dangerous, like sniper, like a bomber, like a military engineer. Some of those skills, if we were to use them in a cash in transit, it can create internal instability and a threat to our national security. So your failure to deal with the benefits of military veterans are posing a threat to our national security, because those people have got specialized skills, and if they were to apply it wrongly because government is neglecting them, it's going to create instability in the country. So with those words...
Yeah, I've raised my hand. Sorry to interrupt you. Chairperson, I did also.
Oh, there are hands. All right. Honorable Atting, Honorable Niaus, Honorable Ala, Honorable Munyai. Over to you.
Chairperson, yeah, let me put it straight. I cannot feel that once again we have been played. Chairperson, you received a letter from the minister stating explicitly that a detailed report to implement the court order is attached, although it was not, and I expected that we would get then from the minister or the department that detailed report on the implementation of the court order. We've got now 60 days left. That wasn't done. Instead, more than an hour was occupied by the TMTT report. Chair, this is not acceptable. We are nowhere nearer to an understanding of what is going to happen. We are failing in our oversight over this process, and we will be held accountable. Chair, I think you need to, and I would like to propose that you urgently write a letter to the minister expressing our concern about the process that is unfolding here, the apparent non-compliance, and a clear intention not to comply, and taking a very narrow interpretation of the court's order. I think you need to do that letter very urgently, Chair, and I foresee that we will have to meet, most probably in the recess, to address this very urgent issue. Thank you, Chair.
Thank you very much. Honorable Niaus.
Yes, thank you, Chair. Let us first of all state that we have received no plan from the department how to comply with this court order. Secondly, I really don't understand why they talk about legal advice now. When did they meet with the applicants, and why did they meet with the applicants if they were to seek a legal opinion? The legal opinion should have followed first. Chair, I'm not comfortable with us as a portfolio committee on defense and military veterans depending on the legal advice of whoever the legal advisors are, that the Department of Military Veterans is now going to consult. We have an oversight duty to carry out as this portfolio committee. And we need to get an independent legal opinion on this whole matter, including the anomaly that the department, together with CMVO, post facto, after the ruling of the court, had tried to interpret and, in my estimation, as I've said in my original input, reinterpret to their benefit the court order. Chair, if we fail to get that independent legal opinion, if we carry out our duties as a portfolio committee on defense and military veterans in terms of our oversight duties properly, we are going to be complicit in not complying with the court order. I want to warn you, Chair, on behalf of the economic freedom fighters, that the route that we are taking now and leaving it in the hands of the Department of Military Veterans to come back with some legal consultation is going to backfire on us. And I want to state clearly to you, Chair, that as the economic freedom fighters, we do not accept such a position because it will contravene the duties that we have as members of Parliament to carry out our duties and the oath that we laid down. We are being played, we are being misled, we are being put in a position where we are going to be complicit in contravening the court order. This cannot be allowed, and the EFF registers our strongest opposition to any ruling that we do not get our own independent legal advice, including also why there had been post facto meetings with CMVO reinterpreting a court order after that court order had been issued. Chair, I want this to be put clearly and unequivocally on the record of this meeting that this is the position of the economic freedom fighters. Thank you.
Thank you very much, Honorable Niaus. Honorable Munyai.
Honorable Chair, in the context of doctrine of separation of power, let the department implement and will conduct oversight. I thank you, Honorable Chairperson.
Thank you. Honorable Mutambi.
Thank you, Chair. I had thought the ambassador has summed this thing well, but the response by the DM, it's worrisome, Chair. The way he has put this matter on, Chair. I should think you needed commitment from the department, from the executive, that they are going to implement the court order, as Honorable Munyai has just said, it's summing it up now. Now, for the DM to come and say, we are going to seek legal opinion. This is what happened, honorable members. The moment you got a court order, especially when it's an adverse finding against you, the first thing that you do, you call your lawyers. I believe there are legal people that are there, so that you study the judgment. You cannot be coming to us now 2 months later, we are going to seek legal opinion, in all fairness. And I've raised a very critical question, Chair, to say, why do you have to be forced by the courts to implement the law that you are supposed? It's part of your daily things that you are supposed to implement the law to the latter, but you have to wait for courts. And this is money, the money that you are saying is not there, because all these matters, then it's gonna have an impact on the fiscals of the department. So these are some of the issues to say, can the DM commit to what you said needs to be done, than to come and tell us that they are going to seek legal opinion, because it's in contravention to the letter that the minister wrote to you. Thank you, Chair.
Can I be given an opportunity to clarify, Chair?
No problem.
Yes.
Honorable Dear.
Yeah, the reality here is that there is a judgment. When we meet, whenever we meet to discuss these issues, we are complied to discuss on how do we implement the judgment, Chairperson. Legal opinion does not mean that we we are going to appeal against the case because we have failed to do so legally, you know. It's just as a legal opinion on sharing what is the difficulty, but we have no other alternative, Chair, but to implement the judgment. The issue is to come back to the portfolio committee on how are we implementing the judgment. Yes, of course, the manner in which we reported there may have been a doubt on whether we are implementing the judgment or not. We have an obligation, Chair, for sure that we implement the judgment and come back to you to say how far have we gone with the implementation of the judgment. What are the challenges of implementing it? But we have to implement it, Chairperson. The members, honorable members of the committee should know that we know understand that we have to implement the judgment. Otherwise, with long procedures, our military veterans, of course, Honorable Nihau spoke about it, and you, Chair, we have an obligation to do so, and it's a matter of must.
Point of order, Chair. Point of order, Chair.
Yes, can we get a point of order?
Chair, the Honourable Minister continues to mislead us as a committee, and he is wasting our time. I suggest that you tell him to rather keep quiet in order to protect himself, because I'm sorry, Chair, he's busy making a fool of himself as usual. Please, Chair, can you ask the Deputy Minister to keep quiet and let us proceed with the meeting rather than this kind of red herrings that are thrown out at us?
No, I hear you, Honorable Niaus, on the concern you have. Let me just allow him to finish, then I can come in with the way forward. Honorable Mkungo?
No, as I indicated, Chair, the decision of the portfolio committee that we must implement, we are going to comply. That's all I can say.
No, thank you very much, Honorable TM. If you comply, that will be good for us, because already we have lost 30 days and we are left with 60 days. And we don't have a plan in terms of roadshows throughout all provinces. We don't have that thing before us. And the problem is that it makes us vulnerable as honorable members. I made you an example of 2 cases in the last meeting. The case of the former Premier of Free State, Makashule, the case of the current Commissioner of the Police, Masemula, of failure to play oversight. Now we know, as the honorable members, about this court order. Our mistake would be to allow you not to comply with the court order as the executive authority, which we as the portfolio committee play oversight on in terms of Section 55 of the Constitution of the Republic. So we know now. And it's not a party story. We don't have to ask you for that particular compliance. It's for you to respect the rule of law and comply with it. And I think, like the whip has said, Honorable Munyai, is to allow you as the executive to ensure that you comply with the spirit and the letter of the court order, because those are administrators of justice and law, and we can't say no to the order they give to us. So I would request that we ensure compliance with that particular order. Secondly, is to agree with the way forward as said by the ambassador, that we deal with a complete plan, which would help us to ensure that we comply with all provisions of the Act in terms of services and in terms of benefits we have to give to members and their beneficiaries. And I think it will assist us, because any other excuse or any other statement which does not help us to comply with the court order, it means that we'll be in contempt of the court order. And I think it's a matter that we can afford, especially for us as members of parliament who have taken an oath of office to comply with the constitution. So That would be my request. Let's leave what Honorable Minister, Deputy Minister has said to be hard on it, but to ask them as the executive to go back and ensure that we comply with the court order. That would be my request and conclusion. And I hope that we will ensure that that happens without us being like we're frog marching the executive, but hoping that we're talking to the executive that we play oversight on. Unlike what we have written to you before that you never complied with, we hope this time you will comply with the court as the other arm of the state of the judiciary. Thank you very much, honorable members and Honorable Deputy Minister Olomisa and Honorable Deputy Minister Mukungo, the support staff from offices of the executive, as well as the portfolio committee. Lastly, Dr. Janse van Rensburg, I would request that we take this matter to the Parliamentary Legal Services for an opinion, in particular this court order, in terms of how, as this particular portfolio committee, can play oversight on it. So please let's involve Parliamentary Legal Services so that tomorrow we must not unnecessarily, as the committee, be charged for failure to play oversight, because it's going to be criminal for us if we're not going to comply with the court order, and we know. So please ensure that we involve the Parliamentary Legal Services. I will be in a position this afternoon to talk to them, the legal services, to help us so that I can see this is not going to end well, because it involves lives of people. And if we are not serious about lives of other people, we may also be found in court as witnesses, because we knew, we never acted and played our oversight. So we may unnecessarily be in trouble. Let's involve the Parliamentary Legal Services to save ourselves in case of any setback or any adverse results going forward. Thank you very much once again, all of us. The meeting stands adjourned until we have received the plans and when the department is ready to give us a report on the compliance with the court order. We will not put it in the program, but we'll make a request from Parliament from time to time to have a meeting with yourselves to ensure that you comply with the court order. 60 days is left. If you don't have a plan, please be advised that we will disown you as the portfolio committee. I thank you. The meeting is adjourned.
Thank you, Chair.
Thank you.
Yes.